1968 ခုနှစ်မြန်မာနိုင်ငံတရားစီရင်ထုံးစာမျက်နှာနံပါတ်689 Mr. E.R. KELLAY Union of Burma Applicant vs. Louis P. Rajindram Respondent ဤစီရင်ထုံး audio book ကိုအထက်တန်းရှေ့နေဦးအောင်ခိုင်ဦးအထက်တန်းရှေ့နေဒေါ်ပြည့်ပြည့်ဖြိုးနှင့်တရားလွှတ်တော်ရှေ့နေဦးထိန်လင်းဦးတို့မိသားစုကစီစဉ်ဆောင်ရွက်ပြီးဒေါ်ယူပါစောမင်းမှဖတ်ကြားခြင်းဖြစ်ပါသည် Criminal Revision before ဦးစိန်သင် Judge Mr. E.R. KELLAY Union of Burma Applicant vs. Louis P. Rajindram Respondent Code of Criminal Procedure Section 526 for every application for the exercise of power conferred by this section to be made by motion supported by an affidavit or affirmation held Section 526 4 of the Criminal Procedure Code lays down that every application for the exercise of power conferred by this section shall be made by motion which shall accept when the applicant is the Attorney General be supported by an affidavit or affirmation. An affidavit or affirmation being an imperative requirement of law, an application and accompanied by such a affidavit or affirmation cannot be entertained. Modile Raniwala vs. the State AIR 38 1951 Atma page 82 refer to Utan Singh for the applicant Mr. S.A.A. Pillay for the respondent Usain Din Judge This is an application for revision against the order passed by the district magistrate in his criminal miscellaneous application numbered 964 of 1966, by which he rejected the application for transfer of the case, which is before the 4th Additional Magistrate, Rangoon. The case relates to the prosecution of the respondent, Louis P. Rajindram, under Section 408 of the Penal Code on the complaint made by the applicant, Mr. Edward R. KELLAY. Administrative Officer of the American Embassy, Rangoon, the transfer was sought on the ground that the trial magistrate allegedly allowed the defense counsel to use a police statement for cross-examining one of the prosecution witnesses and that some indecent or scandalous questions were allowed to be put to the prosecution witness. In his argument before me, Mr. Pillay, the learned counsel for the respondent, contends that this application does not lie as the order passed by the learned district magistrate is one which cannot revise by this court under Section 439 of the Code of Criminal Procedure. His contention finds favor in many rulings, including that of the late High Court, where it was held that the High Court has no power under Section 439 Criminal Procedure Code to revise an order of a district magistrate rejecting an application for transfer of a case made under Section 528 of the said code, and that the remedy in the matter lies, if at all, by way of an application to the High Court under Section 526. The learned counsel for the applicant draws my attention to the caption of his application, where Section 526 of the Criminal Procedure Code is referred to. He accordingly prays that his application may be treated as one under the said section. His prayer, however, cannot be acceded to. Section 526(4) lays down that every application for the exercise of the power conferred by this section shall be made by motion, which shall, except when the applicant is the Attorney General, be supported by an affidavit or affirmation. An affidavit or affirmation being an imperative requirement of law, an application and accompanied by such an affidavit or affirmation cannot be entertained. This is also the view expressed in the case of Modile Raniwala vs. the State 1, where it was pointed out that an application in revision cannot be treated as an application under Section 526 on the ground that the application is not supported by an affidavit as required by law. Even on merits, there appears to be no substance in the application filed by the applicant. No doubt, during the cross-examination of prosecution witness number 2, the court admitted a written statement of accounts made by him as Exhibit L, but this is entirely within the competence of the court to do so. If it is proved and if it, as asserted by the respondent counsel, falls within the definition of a statement made to the police, it can only be utilized in accordance with the provision laid down in Section 162 of the Criminal Procedure Code. But this is a matter still left to be seen, and at this stage, it would be premature to determine whether the trial court has contravened the provisions of the said section. As regards the alleged indecent and scandalous question, the learned counsel for the applicant is not able to cite a single instance where the lower court has allowed such question to be put to any of the witnesses. The principle that has all along been followed by this court in the matter of transfer of a pending criminal proceeding is very lucidly explained in the case of APPLICANT vs. the Union of Burma 2, in which it was pointed out that the main question to be considered is whether incidents that took place before the magistrate are such as are calculated to create in the mind of the applicant for transfer a reasonable or justifiable apprehension that he would not have a fair or impartial trial. In the present case before me, it cannot be said that any reasonable or justifiable apprehension exists in the mind of the applicant for transfer that he would not have a fair or impartial trial until the case is withdrawn from the trial court. I have also gone through the record of the lower court, and I find that many adjournments were occasioned due to the default of the applicant. It is in the interest of all parties concerned that this case should be expeditiously disposed of. If the applicant prayer is to be granted, it would mean further delay in its disposal. For all these reasons, I would hold that it is not a fit case in which transfer ought to be allowed. In the result, this application fails and is hereby dismissed.